Hello and welcome to this podcast. My name is Dominic de Saulles. In this podcast I'm going to talk about Chapter 5 of my new book, Reforming Civil Procedure, The Hardest Path. The book is published by the Hart imprint of Bloomsbury Publishing plc. Chapter 5 of Reforming Civil Procedure deals with sanctions, by which I mean a punishment imposed by the court on a party where it failed to do what it was told. To put this in context, if you miss a key time limit, then you're going to bitterly regret it. You'll have to go cap in hand to the court and offer some serious explanation for your default. Serious grovelling will also be required. Now, in civil procedure, sanctions has been the defining controversy of our era. If case management was a 1 or 2 year wonder, the sanctions issue has just kept rolling on. Why might this be? First, it is not easy to come up with a regime that is rigid enough to bear down on defaulters and yet be flexible enough to be variable in deserving cases. That is precisely where the good ship Mitchell sailed off the edge of the known world. It took the arrival on the scene of Denton to inject a note of pragmatic procedural justice and to sail us back into safer waters. Second, any writer of rules has to decide whether punishment will follow automatically from default or whether the court will have to be asked to impose a punishment. Broadly, the rules opt for automatic sanctions. Fail to do something and the punishment takes effect immediately. But the punishment may simply tie one of the defaulter's arms behind his back, applying the proportional punishment principle, and then still require the innocent party to have to apply for an unless order. Then there is the vexed question of what shall count as a default and what kinds of behaviour are to be punished. It is clear enough that some defaults are to be punished. Fail to give disclosure and you cannot use the documents you would have disclosed unless you get a court order. But what about the cases where no sanction is imposed by rule but a party is not free to act? Faces a restriction, such as cases of default judgment, where a party has failed to take a basic defensive step and a judgment has been entered against them. Here a decision has been made to treat express sanctions and implied sanctions alike. All require an application for relief to be made. Fourth comes the question of what is to count as a deserving case for procedural clemency. The original CPR 3.9 was thought to be too multi-textured, and that multi-texture was thought to have led defaulting parties to being let off. So the second attempt at solving the problem was the new CPR 3.9. But the new rule failed to specify the priority to be given to its three constituent parts: the efficiency objective, including proportionate costs, the compliance objective, and the broader party response objective, all the circumstances of the case. Further, the rule could have, but did not specify what approach to proportionality of punishment the court should take. Then there is the whole question of what counts as a deserving case, and this is tied to the big ideas of what counts as procedural justice, which in turn have been influenced by judicial concern about people not engaging with the system or engaging with the system on their own terms. Undercut that and you undercut the rationale of the civil procedure rules. Sixth comes the big issue of whether the same punishment should apply to everyone. Does one size fit all, or should the court make the punishment fit the procedural crime, as it were? Even this brief tour shows that coming up with a functioning system for punishing default is technically challenging. Chapter 5 sets out in detail how the old CPR 3.9 was thought a failure, how the new CPR 3.9 ran into trouble, and how the reach of procedural punishment, sanctions, has expanded way beyond where it might be expected to have stopped. For those of you who like to think about these things, I've got a couple of questions for you. Do you think that the provisions relating to setting aside a judgment in default and to relief from sanctions actually sit easily together? You can find the provisions in CPR 13.3 and CPR 3.9. The second question is this: is the entry of a default judgment a sanction in the sense of being imposed for a failure to respond to an order? If not, what kind of thing is it? Happy thinking. I hope that you enjoy Chapter 5 of Reforming Civil Procedure, The Hardest Path. Thank you for listening.